I'll start to my immediate left, Kevin Kouzes, who, among other things, is a former partner of mine at Dow Lomas. Now is really on the hot seat. He is the general counsel of Comcast Interactive Media, which is Comcast's, the part of Comcast that is charged with taking Comcast into the internet and running its internet businesses, which are Fandango, the platform, Fancast, Comcast.net, and anything else that one of the most important media and technology companies in the country participates in. I've known since Kevin and I were partners. He's a very gifted media and technology and IP lawyer and business counselor, so it's great to have him here. Cliff Sloan is my favorite underachiever. He, after Harvard College and Harvard Law School, he was a Supreme Court clerk for Justice Stevens. He was associate counsel to the President of the United States. He has worked in the Solicitor General's office, and now he has hard jobs. Now he is the publisher of Slate Magazine, and he's also general counsel of Washington Post Newsweek Interactive, which is the Post's new media and internet company. I'm going to do a rare combined introduction of Jerry Berens and Barbara Wall, sort of combined. Barbara is Vice President and Associate General Counsel of Gannett, where she represents newspapers, broadcast stations, websites. Jerry is a partner at Sabin, Bermanton Gould, where he represents magazines, newspapers, big cable company, and websites. But the two of them are two of a very small group of people that I think would be widely acknowledged in the media bar as sort of the leaders of the media bar and the new media bar. And you know, they've both been recently chairs of the ABA Forum on Communications Law, which is essentially the vehicle for the new media bar in the ABA. I got to know both of them by doing some outside legal work for both of them, but it's funny, the relationship has evolved that now if I'm wrestling with a hard or thorny problem, notwithstanding that they're clients, I will call them up because they've seen things from so many angles, they're so informed, thoughtful and creative about how they approach things. So I now turn to them as the people when I don't know the answer that I go to. So that said, by way of background, I'm going to go ahead and sit back down. I'll pose the first question to Jerry as we start to think about how traditional media has transitioned to new media. One of the main ways that things are different is that the rules of the road are completely different in terms of use of content and content liability online. And one of the cornerstone parts of that is the copyright and the Digital Millennium Copyright Act. Jerry, can you tell us about what the Digital Millennium Copyright Act does in terms of safe harbors and how media companies can take advantage of those safe harbors as they venture online?
Sure. Is this on? Yeah. Dave just said that the rules of the road are different online. They are in one very, very, very significant way, which will be the bulk of what I discussed this morning. But it's very important to step back for a moment and remember that in general, the law that applies in the non-digital world applies in the digital world. And with respect to copyright law in general applies fully on the internet with this one very significant exception, as it does in print media and as it does in television and movies and etc. The basic rule of copyright is if something's copyrighted, someone else who wants to use it needs permission to use it with the exception of fair use. That's the basic law of copyright. And I'm fully aware, as my clients keep reminding me, that there is a notion out there that on the internet everything is free and information yearns to be taken by other people. The law doesn't recognize that. So always bear that in mind, that the regular rules of copyright apply and you need permission to use other people's material. One of those rules of traditional copyright law is the one that gives rise to the difference on the internet. And that is the rule that a lot of people have trouble accepting, that you're liable for when you publish someone else's copyrighted material, even if you didn't realize that someone else owned the copyright in it, even if you thought you had permission to publish it. Let me give you one example of that. It's kind of an extreme example, but a real example that my clients face often. If you're a magazine or a newspaper publisher or a television station, and you're given an advertisement by an advertiser, let's say by General Motors, and General Motors is represented by a big advertising agency, and they give you an ad to publish, and in that ad is copyright infringing material. a photograph of a model standing next to a car, or a video in an advertisement, or music in an advertisement, in a commercial. If you publish it or you broadcast it, and it turns out that the advertiser or the ad agency didn't have permission to use that photograph, you're liable. The media is liable for that. Now, you can turn and go to the advertiser and try to get them to defend you in that case, and 99% of the time, if you're talking about companies like General Motors or Clairol or other big responsible companies, they're going to protect you and it's going to work out fine from your perspective. But on the internet, that's not who you're talking about if we're talking about user-generated content. If you're opening up your websites to material being posted by users, whether it's text or photographs or video or music, the people who are posting there are not just the General Motors and the big advertising agencies, but the bulk of it is posted by average, everyday people. And in many cases, there's no one for you to turn to protect you in case it turns out that what they posted infringes somebody else's copyright. So if the traditional media law applied, many of the user-generated aspects of websites simply couldn't exist because you couldn't bear the liability for it. A website like YouTube could not exist under traditional copyright rules. So Congress passed the Digital Millennium Copyright Act, which they referred to. It's now about 10 years old, and for a 10-year-old statute in such a very active area, there's a surprising lack of legal development, a surprising lack of legal cases that have determined really what it means in its picky aspects. The courts have pretty much made clear that it applies to routine websites, but they haven't gone much beyond that. Right now, there's pending a number of cases against YouTube that I'm sure you've heard of, in which many of the issues that I'm about to discuss specifically are going to be directly addressed, or at least are raised, and if there are court decisions in it, they'll be directly addressed. Okay, so what does the DMCA say, and how do you take advantage of it so that you can operate user-generated or websites using user-generated material? The DMCA provides a safe harbor, that's the term it uses, for websites and other service providers who are hosting material posted by users. In order to get the benefit of the DMCA, you have to follow certain procedures. The first one is you have to name an agent that people can contact if they feel that their material is being infringed. They got to have an easy way to find someone to complain to. One of the things to bear in mind when you name that agent is make sure that the person that you're picking and the contact information you're putting in for them is something that's stable. Something, people change, people's jobs change, people leave companies. You need to make sure that that every time someone leaves a company, you don't have to go changing who your agent is, because the agent has to be registered with the Copyright Office and has to be put in a conspicuous place on your website. So you don't want to have to change that every time you have a new person. And you also want to make sure that every time you start a new website, you're also making sure that you're registering that agent with the Copyright Office. Many companies, especially in their promotion departments, start up websites every day for various promotions, sweepstakes, partnerships with advertisers and promotional partners, etc. You need to have that agent for all of those, and you need to register them with the Copyright Office. Second, you have to have a policy and post a policy that you're going to terminate repeat infringers. It sounds very easy. Becomes very difficult when you try to determine what is a repeat infringer. You have to have like a little mini hearing or mini trial every time you get a complaint. Is a repeat infringer someone who simply has received a lot of complaints about what they posted, or do you actually have to determine that they really have infringed copyright? No legal development on that yet. And third is what's referred to as the takedown procedure. If you get a complaint, if the agent gets a complaint from someone that their material is being infringed, the rules are, and I won't go into all the time periods, although there are lots of specific date time periods in the statute, you need to take down the material, you need to notify the person who posted it that you received a complaint about it, give that person an opportunity to object to the taking down on the ground that they either do have a license to use it or it's not owned by the person who complained about it or whatever. And then if you get such a counter notification, as it's referred to, you put the material back up unless the copyright owner actually sues within a very limited period of time. I think it's 10 to 14 days. It's a little bit of a complicated procedure that if and when you ever get into it, your lawyers hopefully, or the lawyers here, will obviously look at the statute to see exactly how you do it. But those are the basic procedures for being entitled to the safe harbor under the DMCA. There are also some conditions that have to be in existence before you're entitled to that protection. One is the material has to be posted at the direction of the user. Now this is a very key issue. That's the language of the statute. You have to be hosting the material, quote, at the direction of the user. Barbara's going to talk in a couple minutes about another area of law that excuses websites from liability under traditional principles, where this rule doesn't really apply. But here is a significant difference between what Barbara's going to talk about and the DMCA. If material is being posted by your users and you're screening it before it's going up, or you're choosing what they post to put up and what not to put up, the material is arguably not there, quote, at the direction of the user. It's there at your direction. Imagine the user presses the submit button, the material goes directly to your website. It's there at the direction of the user. But if it goes to you first, and you stop it, and you start looking at what am I going to put up and what am I not going to put up, and you're the one ultimately who presses the submit button and puts it on the website, I think it's there at your direction, not at the direction of the user. No courts have addressed that. This may be addressed in the Viacom lawsuit against YouTube, but this is a key issue for websites that want to keep their sites clean. If you don't want pornography, racist material, violent material, etc. on your website, or you want to make sure that the material that's being posted to your website is on point, that it's about the topic that the website is supposed to be addressing, then you have a dilemma. Do you pre-screen and run the risk of losing your safe harbor protection for everything that's gone through, because everything on the site now is there at your direction, or do you let everything go in and take it down after the fact? That's okay. That everyone agrees is okay. If it goes up and you take it down, that's okay, but the material then is up there for some period of time. So that's one of the conditions to be entitled to the safe harbor. The second is you can't know that the material is infringing. Now, this is a key issue in the Viacom lawsuit against YouTube. Viacom says, of course YouTube knows this stuff is infringing. It's kind of the come on approach. We all know that this material on the website is infringing. How can YouTube pretend that it doesn't know? YouTube says, this is all ones and zeros. We don't know what's up there until someone tells us what's up there. There's a lot of stuff up there that's not infringing. So we don't know that the material is infringing until someone tells us, and that's when we take it down. And the third condition that you have to have for entitlement to the safe harbor is you can't directly profit or directly financially benefit from the infringement. Another key issue in the YouTube case. Many clients want to sell advertising, obviously, on their pages, including pages that have user-generated content. Is selling advertising on pages that have infringing content mean that you're directly profiting from the infringement? My personal view is, that selling advertising on the page that has it is not directly financially benefiting from the infringement, but if you tie it into the infringing material, it is, or at least runs the risk of being declared to be that. For example, pre-roll of video. A lot of websites allow people to post video. If you put pre-roll advertising on that video, I think then you're running the risk of being declared to be financially benefiting from the infringing material. But a mere ad on the page will not hold that. YouTube takes a very conservative position. I've discussed this with them. They will not sell advertising on pages that have videos unless those videos were posted by partners that they've entered into contracts with who are representing that the material is clean from a copyright point of view. So if you go to YouTube and just flip around pages, you won't see advertising on the great majority of YouTube's pages. The only pages you'll see advertising on are the ones where they've entered into an agreement with someone who's posting material and representing it.
Can I just make a little point there? What I hear from our business folks is advertisers don't want sponsored user-generated content necessarily because they're very wary of what it might contain. And so this is one of the rare situations with business interests and legal interests come together.
One interesting development, increasingly advertising is contextual advertising we're going to see attention here because ads are going to find content that appears to relate to the ad. So even if you don't intend, you don't make a conscious choice, yes, I'm going to sell an ad that is next to a user-generated song about what you're talking about, there may be automated processes in your ad serving, your ad serving partner may be serving contextually relevant advertising.
And one other point. I mean, Jerry is giving appropriately conservative advice, but I just want to hold out the possibility of asking a question. You can have users certified just like partners. that before they put something up, it's in compliance with copyright. And let's say that you have a site where generally the user-generated content is in compliance. You have 1,000 user-generated videos up. 999 are in compliance. The 1,000 is not in compliance, but the person certified is in compliance. I think if you're running pre-roll on all 1,000, and it happens to be on that one of the 1,000, that's not the kind of profiting from infringement, I think, that the DMCA is talking about, or that you see at issue in the YouTube case.
Yeah, I don't know. If you're the copyright owner of that one video of the 1,000 that's been
Yeah, but I mean, if you then have,
but
if you then have a process, like kind of promptly responding, to the complaint and that kind of, I just think that's a vastly different situation from the YouTube complaint, which is premised on the idea that the entire audience is kind of, or some massive quantity is founded on what is known to be.
right, which is the core of the complaints against YouTube. But let me just make one last comment on that issue and the Viacom against YouTube case. I described that YouTube takes a relatively conservative position by not selling advertising at all, even flat, regular old banner ads on those pages. And Barbara correctly pointed out there's a good business reason for that also, although the legal reason is part of the reason to do it. Viacom takes the exact opposite position in its complaint against YouTube. Viacom says even though there's no advertising on the pages that have Viacom infringing content, the content that infringes Viacom copyrights, they are still financially benefiting from the material infringing Viacom's videos because that material attracts people to YouTube. Once they're on YouTube, they wander through other pages. Some of those other pages have advertising, therefore they're benefiting from the advertising as a result of the material that infringes Viacom's copyright. So they take an extreme opposite point of view on this.
It's one of the questions. Is my mic on?
Yeah.
Okay. One of the questions that I would say comes up as often as any for me in this area is we'll have clients in broadcast stations or newspapers that they want to have a connection with users, so they tell users, post your video, and here's what we want you to post. You singing a song about the local college football team, or you doing whatever. And the question is, if you are inviting people, the average person that Jerry was talking about, to post a song, you know that most people are not going to go out and get the necessary music clearances to have created that piece of music. Do you then have the actual knowledge, or are you on notice that the material may be infringing so as to render you ineligible for the license and for the safe harbor? And I will tell you, Jerry talks about the surprising lack of case law in this area. There's no case that I can get found in this area, but again, that's probably the most common question that I get is how much can I tell people what I want them to send me before it's sort of as me? And I don't know if you have...
We know that there's a little bit of development in the related area that I don't know if I mentioned in the roommate's case, but in the CBA there's a little bit of development in that area. But one of the things we advise our clients is one way to deal with that issue is to say in the rules that the music has to be original. Don't allow them to use commercially available music, so that you're not dealing with the phony issue of believing whether they got licenses from the Rolling Stones or the Beatles or whoever, but require that it have original music in it.
Shall we
Yes,
switch to
that way over.
That's a good question about the filters real quick. When you're talking about the material posted at the discretion of the user.
Direction
Of the user. How do pre-screening filters that are automated, they're not being manually run?
Very good question. There is actually one case, one decision in a lawsuit that suggests, it doesn't directly hold us, I don't think, but suggests that a very limited amount of screening, even human screening, might be okay for these purposes. There's only one case, and it wasn't really the key issue in the case, but it was a case where they were screening to prevent pornography and to make sure that the pictures that were being posted are about the subject. Even under that case, you got to be careful about where you're drawing the line between that and you're simply picking and choosing what you want to post and what you don't want to post, which is not what the DMCA was meant to allow. We think, and again, no laws, no case as far as I know has declared this, we think that automated screening is okay. that if you have filters that are preventing swear words or racist terms, or to the extent we can with video, I know that's kind of in an early stage, but to the extent we can with video, preventing it from going up. You know, YouTube is experimenting now with digital fingerprinting with video, which is a whole other controversial issue between them and the copyright owners. Our view is that that's okay, that that is not interjecting your direction between the user and the website. But no court has declared that yet.
Before we leave this entirely, I think we're leaving the audience with the impression that the best conservative advice is not to filter, not to moderate at all. And I think that's right, but I mean, I can definitely see situations where you probably want some human filtering of the user-generated content. I noticed when I think Jerry mentioned about promotions of contests that a lot of heads in the audience were nodding. So that's something we might all do, to have a user submission for some wide-line product screen or something like that. Those types of things where you have brands to protect, other reasons that, well, maybe your own standards, such as no nudity, no excessive swearing.
Or it's a child-oriented site.
A child-oriented site, another great example. So I made a couple points on moderation, I think. First of all, while Jerry's exactly right about the DMCA and what it says, the DMCA is an exemption to copyright liability. If for some reason you have fallen outside of the exemption, it doesn't. The converse is not necessarily true. You're not automatically liable. You can still have defenses. You can still have fair use, other defenses.
Damages.
Right, and plus it is nice sometimes to go into the court in a copyright infringement case and say, I did the right thing. I tried the screen. So we should at least talk about that. And a few suggestions if you want to moderate. And these are things that Comcast has done on occasion. You can't have moderators answer fair use questions. Those are next to impossible. Reasonable minds are going to differ on these things. You could have them filter for something, for example, like just flat-out originality. So, in other words, last night's clip from Saturday Night Live is not original. Any moderator with limited training can remove that for us on the website.
Perhaps someone in a third world country on contract at $6 an hour.
It may even be possible. The other thing you do, these types of focused user-generated things, contests and promotions, there will be a call to action. So you're not asking for videos of last night's Saturday Night Live or anything you thought was cool or someone's kids, the kind of stuff. It's focused, targeted promotion. The moderator can at least screen for this is responsive or not. And depending on how you phrase the call to action, then you could be handling some of your claims proactively at the beginning that way. And then I think the third maybe level of filtering is just your own content standards and policies for whatever website you're running. You're probably on the screen for, is this the right thing to do? Screen for nudity, profanity, or child oriented, like we said. And I think you could put a moderation team in place with those three objective filters. There's definitely an argument the DMCA exemption may not apply because theoretically you've now seen the content. It wasn't automated. It may not be, like Jerry said, at the direction of the user. But they may still be good defenses that you're not contributory liable with that if you ever did get the claim. Of course, part of the goal is to avoid the claim in the first place.
Yeah, question. So that was great, what you described, very helpful. Does DMCA exclusively cover copyright, or is the safe harbor provision apply to anything else, like other forms of liability, trademark, slander, libel, things like that?
All right, now you have segued
Okay.
into Marcus.
And I want to, I don't know how I'm going to explain that you have to keep this clear in your head. What I'm going to now talk about is not about copyright. It specifically excludes, the statute that I'm going to talk about specifically excludes copyright law. And whereas Jerry has described the very complicated requirements of the DMCA, which have the safe harbor, et cetera, with technical steps that have to be taken, notices provided, et cetera. In the context I'll be talking about, there aren't any specific requirements like that. And let me just tell you a little bit about background here. I must say I've been around for a while. I joined Gannett in 1985. And at the time, Gannett was entering into partnerships with the CompuServes of the world. And we were talking about, let's find new delivery trucks for our content. So I've been at this for a long time. And during the early days of putting content online and possibly opening that content up to a little bit of discussion with users, the laws were very strict as applied by the courts. And I'll explain that to you. back in the pre-digital era. You had claims, obviously, over content. Now, I'm not talking about copyright. I'm just talking about like libel and infringement of other types of rights of privacy and so forth. They've always, it's ever been thus that people are offended by what you publish. And what the courts held is that if you're a newspaper publisher and you put, let's say, a story that's written by one of your reporters in your newspaper or on your TV station, quite obviously you're going to be responsible for that content. They also decided that because newspapers were heavily edited and the content was, newsprint is expensive, and the editors would select very precisely what they wanted to be in the newspaper, even when it was provided by a third party, like a letter to the editor, for example. The court said, you put it in the newspaper, you're responsible for it. Now, by contrast, still we're talking about this pre-digital world. Bookstores also sold content, books, magazines, etc., that would offend people. They would think it was libelous, or they would think that it infringed their right to privacy, or what have you. And the courts had decided that a bookstore was not responsible for the content because they didn't select what went into those books. So along comes the internet and the issue of whether or not a website or an internet service, which is what they were called back in the mid-1990s, would be responsible for content that its users posted. So the first court that really looked carefully at the issue, and there were some other decisions, but in any event, the court said, okay, is this, and it was a suit against Prodigy. How many people remember Prodigy? Okay, Prodigy was billed as the family-friendly internet service provider. If you had kids in your house, you wanted a clean, well-lighted place, and Prodigy was it. So they would screen for dirty words, and they were, careful about what got posted on the chat boards and so forth. So in any event, Prodigy gets sued by a company whose practices were criticized, and the company alleged defamation on one of the discussion boards. And so the court is looking at the issue, trying to decide, is Prodigy like a newspaper, or is it like a bookstore? And so they started looking at Prodigy's practices and noticing, for example, that they did screen out anything that was pornographic or bad words, curse words, etc., all in the effort to put together a product that's appealing to families. The court said, well, that looks like a newspaper to us. And so the whole world was aghast, because what that meant is, I'm talking about the fledgling internet world, what the court had basically said is, if you do anything to make your site a better place, you're likely to be deemed more like a newspaper than a bookstore. So everyone was concerned that their websites would quickly become polluted with racist, libelous statements, etc., and they wouldn't be able to do anything about it. And so Congress in 1996 passed the Communications Decency Act. And obviously there are a lot of provisions in that act, but one of them was addressed specifically to this issue, and that is, are websites or internet service providers going to be responsible for the posts that their users type onto the site or the service? And the court decided that it was bad policy to put the websites on the hook for doing any sort of editing of those comments. So they wanted to take away the disincentive to that type of editing. Does that make sense to you guys? Because, remember the court had said, oh, you're looking like a newspaper, that's not good, you're going to be responsible for all that content. So they wanted to take away that disincentive. And they did. And they said that the internet service providers, now been interpreted to include websites, are not responsible for material posted by third parties. There aren't any complicated requirements to get that protection as there is in the DMCA. That's just the law. And unlike the DMCA, where there aren't a whole lot of cases, there are a lot of decisions under Section 230. And believe me, with the development of the web and sites that are a little bit different than the Prodigy family-friendly internet service provider of 1996, the the law has been pushed to its limit. For example, there's a website called don'tdateandgirl.com. And don't get, a lot of women always smile when I mention that, but it's about, you post about that ad and warn other women not to date your former boyfriend. And so, one of the guys who was criticized on that website for a lawsuit claiming that this was invited statements, that the website was set up exclusively to contain this type of libelous material, and therefore the website shouldn't be able to get off the hook for that content. The court said no. For the most part, over and over and over again, the courts have said no. There is one case, though, that's still in the courts where the decision was made that the website might be libel. It's not in the area of libel, but rather the Fair Housing Act, which, I don't know if you know anything about this, but anybody who's been in the newspaper business knows that ads for housing are not supposed to specify race or gender or family status or any of a number of other types of requirements, for good reason. I grew up in the South and in New Orleans, and when I was growing up, the classified advertising section of the newspaper was segregated by race. And so seeing that, Congress a long time ago passed this Fair Housing Act, which says ads for housing can't have those types of provisions in them, and the newspapers or other publications that take those ads are responsible for the content. So with respect to this site called roommates.com, the site allowed for the people who were advertising back and forth for apartments and so forth to include all sorts of gender preferences, sexual preferences, you name it, that the website allowed the users to post that type of information. And the court has actually called into question whether or not Section 230 applies to that particular website. So many people in the industry are concerned about that case. I am too, although I think personally, and I'd be interested in what others think, I think that roommates.com website turns computers into a Fair Housing Act violation machine. And it's different than setting up a forum where you're soliciting comments on, an election or what have you, or even on bad boyfriends, where you don't know what people are going to post. The roommates.com creators had to know what was going to be selected, and had they thought about it, they should realize that that might be in violation of the Fair Housing Act.
Let me just say that there's an interesting kind of business issue that comes up with how that legal issue plays out, because Barbara was mentioning newspapers and newspaper websites, and for a couple of reasons, the newspapers and newspaper websites take great care to review the ads and to have them not be discriminatory, both because of the Fair Housing Act and just generally because of the kind of reputation and the kind of ads that the newspaper wants in print or online. Roommates.com, Craigslist, other places like that don't do that kind of screening, which is labor intensive and takes expense. So there is an interesting kind of business implication.
Exactly, and a lot of, it's free on Craigslist, so a lot of this advertising has migrated away from print products in any event. But for our purposes here, talking about what liability a website has for posts by third parties, if you're outside of the copyright area, the courts have held that if it's third-party content posted by third parties, you, the website, are not responsible for it. Now, just carrying that out a bit, you can imagine the confusion this creates for people who run websites like ours, and also perhaps for the readers of those websites, but I'm not going to speculate on that, because most of the websites are run out of the newspaper newsroom, where on the one hand, preparing material for the print product, the rules haven't changed one iota. You're still responsible 100% for the content that goes into the print product. Yet, online, you're only responsible for the material that's posted by your reporters and other staffers. third-party content, whatever it may be, is, you know, section 230 protected material. So then, of course, all under one roof, that editors and online directors think, this a lot of good stuff coming in on our website and a lot of interesting posts. Why don't we start repurposing that material and putting it into the paper? Yeah.
How about trade secrets? If you know, if the use is unauthorized and taken from somebody else, separate from copyright.
Yeah.
So,
Let me mention something about that.
oh, okay. I'm
Good
sorry.
question. No, not sorry. It's a good
It's a
question.
good question,
Okay.
Jay.
Going
Let's ask
back to the
them.
person behind you who asked whether the law I was addressing was specific to copyright. Yes, the DMCA is only about copyright. However, the exception in the law that Barbara is describing, the CPA, is not specific to copyright. It's all intellectual property. CPA does not protect against liability for any infringement of intellectual property. Intellectual property is a lot broader than copyright. Trademarks, patents, and trade secrets are intellectual property. There's no law that specifically addresses or creates an exception for those forms of property. So, at least theoretically, more than theoretically, legally, you are liable, the website is liable for trademark infringements, patent infringements, and trade secret violations that are created by their users because they're not protected by either the CBA nor by the DMCA.
Practically work.
Nothing.
Nothing. I mean, practically speaking, at our websites, and by the way, Gannett, oh, I'm sorry, did you have something?
No, absolutely.
Well, at Gannett websites, where about a year ago we decided as a company that we wanted to bring the users into the online community in a big way, and we virtually every story that appears on one of our websites has a story chat attached to it. We have forums. We've even done what's called crowdsourcing of news stories, where before a story is written, the newspaper will solicit information from people who are, you know, reading the website, and some really interesting journalism has resulted from that. But nevertheless, we really want to have the users come onto our websites, and we also don't have much. We don't have 24/7 staff to review those comments. So on a Gannett website, chances are you're going to see things that haven't been deleted yet because nobody's seen them yet, and it can get ugly. And I'm not saying anything that those of you who have been associated with websites don't know. There's a lot of racism in this country. There are a lot of hateful views that get posted on these websites. Now, in terms of the practice, because the newspaper is, you know, has its brand at the top, and wants to be seen as a responsible community member, the chances are that the editors are going to want to take that stuff down. And under Section 230, they can. I mean, remember, that's why the statute was passed in the first place, so that editors would not have a disincentive to make their websites that sort of clean, well-lighted place. So my advice to our web editors is, if you don't want it there, take it down. You can take a whole thread down, you can take the comment down. And indeed, we've introduced some new software that has plug software, if anybody's familiar with it, which has all sorts of features, including one where if 3 or more users, unique users, object to a particular post, even before an editor or some other person has seen it, it will come down and be put into a sort of holding bin because of the complaints.
How does, and this might be more of a digital millennium, copyright application, what about copyright content that has ads embedded, where the copyright holder of the content wants to take down, but there's an embedded advertisement which is owned by someone else? Does the copyright owner have the ability to take it down with the embedded ad, or are you obligated to let the ad get posted?
Legally, first of all, as you know, advertising is protected by copyright.
Right.
Although, as you pointed out, it's a
Separate.
different copyright
Yeah.
owner than the editorial material, let's call it, that surrounds it. The copyright owner who sends a notice under the DMCA can only complain about what they own exclusive rights in. They can't complain about what someone else owns any exclusive rights in. As a practical matter, if you're going to take down material that's been posted on a website and in it is an ad, you're just practically, you're going to take it down because it's all part of the same thing, and that's fine. There's no liability for taking down material that hasn't been complained about. So I don't know if that addressed your question, but
And, you know, the normal ad terms and conditions would give you the right to take down the ad.
So for instance, if going back to some of your examples with YouTube, if someone posts a piece of copyright material from Saturday Night Live and it just so happens the ad has been cut out of it. And
The ad that was on the show.
On TV.
Oh, I see.
And NBC says, take that down.
Right.
That's my program, but there was a Heineken ad that ran.
There's no liability to Heineken for taking that material.
No, not Heineken. Is there any liability to NBC or YouTube for taking down a Heineken ad, which Heineken owns? Heineken may not want their ad.
You can always take down, as a website, you can take down anything they want, and the DMCA specifically says you can't get in trouble for taking something down, even if they would want to ask you to take it down. But you can take it down period.
Excellent. Thank you.
I just wanted to elaborate on Barbara's answer to the earlier question about what are people doing, because I do think there are a few practical things you can do to enhance your position, and one of them is the kind of terms for user-generated content that you require the users to certify that it's not violating any intellectual property. All of this is just, none of this is 100% perfect, but there are things you can do to put yourself in as good a position as possible. And then there are, a few different kind of moderating, filtering kinds of things for certain types of things that wouldn't work as well for trade secret. There's obviously, as was talked about, automatic filters. You put in place a thing so that users or can complain that something's unauthorized, and then you need to have a system to respond to those complaints and address them promptly. And again, you can do something similar even without the statute to what the DMCA processes that Jerry's talking about, but that people have a chance to kind of notify you. And then even though you can't have people review every piece of content, we do have people kind of roam and look for things and kind of spot check, and particularly when it's controversial. The user reporting thing, which sometimes works very well. You give people an opportunity to complain, you respond to it promptly, you can defuse the situation. You don't always get exactly what you anticipate. Let me just give you one anecdote. A couple of weeks ago, the editor of WashingtonPost.com, there was some particularly controversial political article. So he wanted to check out the complaints on the comments and see if the language had gotten particularly extreme and that kind of thing. So he was looking at the first request for takedown of other comments, and in the space where it said reason, it just said Republican. So you don't always know.
Well, let me give you another example of that.
Not sufficient.
I am the copyright agent for all of our clients' websites, which means I'm the copyright agent for literally hundreds and hundreds of websites. And unfortunately, the law requires you to have an email address to communicate with you. And as many of you know, I'm sure there are bots out there that scour the internet looking for email addresses to send spam. I get 600 to 800 emails a day to this copyright address, literally 600 to 800 a day, all of which are spam. They're all garbage. All the body enhancement things and all the mortgage things and everything you can imagine. And buried in them, once in a while, once a month maybe, is something that's not spam. Usually that thing is not a copyright complaint. Usually that thing is someone who wants to give their mother-in-law a subscription to Vogue magazine, or literally I've gotten questions asking me what's a good dish to serve with something. The reason for that is the nature of the class. I represent Vogue magazine and Gourmet magazine. So people think that I'm Gourmet magazine.
Why didn't I think of that?
Once in a while, once in a very long while, there's a copyright complaint in there. Now, it's funny, but it's really concerning because I've got a poor paralegal whose job it is to go through these 600 a day and hopefully not miss the serious ones that are in there. It's actually a serious problem.
It seems like, and again, getting back to the uploads in this process for protection, by the time you get that email, that Saturday Night Live episode that you talked about, not only have there been hundreds of thousands of views and impressions made of that, but there have probably also been tens of thousands of uploads all over the place. So by the time you get it, and then now you're sending to maybe the one or two, or maybe there's a few uploaders that you know about. Please stop doing this, or you have the rights to it, going through whatever exercise the act requires. The damage is already done, particularly for the type of content that does spread virally on the internet. Timing is really where it has the most value. So by the 10 days that pass, by the time you're done with your exercise, the copyright has a value.
Trying to see if you have Viacom on your
That's
one of their biggest allegations.
But
They
I-
got these users dramatic, but they're not good enough.
but the practical reality is that, yes, you're right, a lot of it's copied and spreads virally. A lot of the viral spreading is through embeds. And when you take it down from YouTube, all the embeds disappear. But yes, you're right, that's what the copyright owners are
And
doing.
depending on what your goal is with whatever this user-generated product is, I mean, that brings up again the question of filtering first versus allowing some infringement to happen and trying to remain, I was about to say ignorant, but it's DMCA compliant.
But
In
then
some
you raise
cases, they
this
might do the
issue
same thing.
of the pre-filter is an open issue of law currently as to whether there's liability and where there's liability for pre-filtering. So you can see where companies.
There won't be liability for pre-filtering, like this, the point I was trying to make earlier. What there is that an exemption to liability might just
Lack of immunity.
Yeah, lack of absolute immunity. And even that absolute immunity is just, it's not really immunity, it's a defensive one has to prove. And that's the lack on YouTube.
Let me just ask those on the panel, maybe those in the room, for our Gannett websites, we have broadcast websites, newspaper websites. For the most part, the text comments are not in the same places where video or pictures will be uploaded. So, you know, again, remember I wanted this Chinese wall between Jerry's advice and mine. So when we're screening for text that's offensive or in other respects inappropriate for our site and taking it down, we're not doing the type of eyeballing that would get us a DMCA liability or trigger our loss of immunity for that type of screening. Is that true for most websites still? The text and video and pictures are separately solicited and cordoned off in various different areas of the
Often
website?
with the moderator and this forum type of thing, there could be a forum moderator that is sort of screening by a different name.
Yeah.
And not often proactive, it could be less. I think you pointed out something that we might all not be getting right, where these forums and things like that, chats that we offer are user generated the same way that the user uploaded video.
Right, and people post entire articles from newspapers and magazines.
And 99% of the time, maybe a prompt response to an email complaint, or however the complaint arises, diffuses the claim, whatever it be it copyright or offensiveness or trademark claim. And sometimes we have the tension that you have different rules that could apply whether the claim is based on copyright or the claim is based on defamation or something like that. And if anyone's ever done plaintiff side work, you always look at the kitchen sink. You're not just.
Well, we all do. All of us are both copyright owners as well as copyright users, and we are also in the position of going after other people's websites who are allowing our material. You know, photo features from Vogue magazine or GQ get posted all, sometimes before they come out, sometimes before the magazine is actually issued. Somehow an issue gets out one way or another, and we find covers or entire photo features spreading on all the fan sites.
I would also just echo the comment that was said before that you're always best off doing the right thing. And I actually would not kind of shield ourselves from it because of fear of losing the exemption. First of all, it's an open question. I mean, I can make a good argument that it still is at the direction of the user, even if you're knocking some of them out sometimes. The user's telling you to put it up subject to your standard, you know, or whatever. And it's just, I don't agree with going through contortions where you're losing control of the content that's going on your site because you're preserving the exemption. As I say, I think always doing the right thing always makes sense, and it's gonna seem
I'll give you a little bit of. I agree with you 100%. But what we've found on our websites, and we have hundreds around the country, is that when the moderator becomes very active in taking things down that are offensive, it's like tar bait, because everybody in the user and poster community wants to know, why did you take that statement down, but you're not taking this statement down that I've complained about? And they're always testing, why did you do this and not take that down? And it becomes really a nightmare for the moderator to try to sift and sort that out. So some moderators will say, well, let the community police itself. We don't want to get involved, but then that's really not the right answer either. Yeah.
I wonder if you could comment. Has there been a massive takedown of video content clips from Fox News or since the Viacom suit, have the media companies that jumped on that and said, I'm gonna support what they're doing, and would really ask for the takedowns to be done in an aggressive way. I think my thought is that when I go on YouTube, I still see a lot of stuff that's there and there for a long, long time, and it was never asked to be taken down.
Those that have not entered into partnership agreements with YouTube, yes, sports leagues, other television, movie companies, music companies, they all send requests to YouTube. And the reason you see a lot of stuff on there, besides the natural delay between when someone posts it and it comes down, is they take it down from one person, but 12 other people post it. They have to contact them again for those other 12 with the specific URL that they're at, and while they're taking those 12 down, another 20 are posting the exact same material.
And those people are getting new email addresses every 5 seconds,
Right.
so that, you try to block them, but you can't, because.
Does a partnership agreement cover, let's say Fox News partners with YouTube? Does that cover postings made by individuals?
It covers postings made by individuals that Fox blesses.
Only for posters that they bless. Is that right?
Well, no, individual
Not
posts.
necessarily.
Fox is not saying to, my clients have an agreement. We have not said in that agreement, we hereby bless in advance anything that anybody posts that comes from our material. We certainly can post material, and if users post it and it's pointed out to us by YouTube, for example, they get a complaint from somebody, we can say, we certify that's okay. But we haven't blessed in advance anything that comes from our
So
material.
you get to make the judgment on
Right.
independent.
But it's after the fact, right?
So those are, user posted materials after the fact, correct. Our experience with YouTube, by the way, as a complainer, is YouTube is extremely responsive. Our material has come down in less than an hour when we complain to YouTube. Videos, for example, from our websites. The movie companies and the television companies say, that's great when you're sending a complaint about one thing. We're sending complaints about 6,000 items at the same time, 6,000 posts, I say, at the same time. There's 50 of them maybe of the same video. They're not so responsive, especially when they describe it as kind of a game of whack-a-mole. When we complain about 6 and we take them down, and 20 more are going up, and now we have to complain about 20, and 50 more are going up, all the same thing.
The irony, I see hands that are up. What I fretted about last night is, oh gosh, 75 minutes, what if we run out of stuff to talk about? Doesn't seem to be happening. We could talk about the DMCA,
Before we move on, I want to make sure one thing that Barbara said before the discussion part started, because I'm afraid it'll get lost. Barbara was emphasizing that all these rules apply to the web, not the repurposing in other media. Not, you take these pictures, articles, videos, stories, whatever they might be, and put them into your newspaper or magazine or television station. None of these rules apply. All the traditional rules apply.
And with that in mind, Kevin, we do have still traditional rules apply online. And all licensed content for our business. We've been talking about third-party, user-generated stuff. Let's talk a little bit about how we decide what we want to put on. Why don't you talk about how you
I think this gentleman here brings up an interesting transition point for us. So if, let's say I want to make a website, or one of our clients wants to make a website and it has news, and we want robust video from Fox News or something. There's a threshold decision to make whether to go to Fox News and license this the Comcast way, like our cable business. Or, I can do, let's just call it a Web 2.0 business model. I can invite my users, I can make a news channel, invite my users to submit their favorite video news story, and maybe hide behind the DMCA and say that this is interesting, I don't really know that Fox News content, ABC News content.
A little louder, please.
Oh, sorry, Mike. So there, you have a fundamental question whether to let your users do something for you. I think you can summarize Web 2.0 that way. Users are doing things, and people are building businesses around things that around things that users are doing. Or you do go the professional license route. So it's interesting to see us when you're going the professional licensed content route, you still must compete with the Web 2.0 business, and it puts you in an interesting situation. Let's maybe transition to let's get licenses for broadband content somehow, whether it's text, video, whatever it might be. There's always a challenge where the licensor of the content owner, wants to put the distributor in a little box. It's tightened into a box that can't do it.
Yeah, I'm interested in the issue of user-generated content where the website, let's say YouTube, is actually serving as an agent for unsigned talent. Okay? So the issue of agency can be fine. become a record label or become a video label or a partner of the user, then in fact the people who are selling advertisers and are in fact the people on the website become the partners for purposes of exploiting that content. I was wondering if you know of a decision that's come down in that area, because really that's what YouTube is. It is an agent. It is serving as a William Morris agent for unsigned talent.
I think that's only one of many things that they
What?
Maybe they're that, but I think they do a million other things too. And I'll give them a little bit of credit for having lots of interesting user-generated content that isn't commercial. I don't know what the percentages are of all the decline operations. I don't want to make them that short, but we finished up this licensing point a little bit about there is the age-old problem of when you license content that the licensor wants the distributor in a box, as tight a box as possible. Cable television, North America, distributed by wire and the paper too, and just keep on going. So that question always occurs. It's a lot worse in the broadband environment, because I think we all look at several times I've been involved where we're doing something we'll call the Magna Carta of broadband content with a big we're just trying to get it right 6 months from now. You think you get it right 6 months from now. You look back. You almost know now. We've been through it enough that you know the broadband license is going to look silly. We were talking a little bit with colleagues earlier about the goal is not to be in breach of a technical license provision on day 1 of the agreement. It's really hard. It's very hard not to do it, and just a few things to throw out about that. I mean, you got distributors have to be as broad as possible, and I'm kind of making my plea for content owners to go along with it. Second point, license related to the box. Content owners like to license by device, and in broadband that is essentially impossible. I mean, there may be some. Usually I'm talking too loud. You could have some issues. There might be some technical way to decide what device is on the end of an IP delivered network. It's really coming next to a box. Someone has an iPhone. You have no idea if it's a phone or not. Is it a phone? You have no idea it's a handheld. You have no idea it's not a PC connected to someone's bedroom at home.
Yeah, Kevin, the way I've confronted that in the past was, it used to be very hip 10 years ago to have to put into your licenses that you could distribute via the internet. If you have a license from 10 years ago that allows you to distribute via the internet, does that let you send things to mobile devices today? Probably not. So you
I think it depends on who you're asking and what context.
Right, I agree, but at least there's a question about whether or not you covered that. So you really need to be, as Kevin is saying, as broad as possible, and not think that you covered everything by referring to the internet.
And one more issue before we take all the hands raised up here. I think, so let's just assume that you might not get it right from day 1. You could be in breach of the technical provision of license agreement. I think there's an open question when you're in this license situation. Does fair use still apply to me? Are there still some things I can do that might not be in the four corners of my license agreement? And you have again this Web 2.0 distinction between traditional media and new media, which another way to phrase it is sort of the what would Google do approach to legal analysis. So let's say you got licensed broadband content. To take an example that's not too far-fetched, I want to promote my website content by putting an application on a Facebook page, an embeddable widget that maybe displays thumbnail for 10 seconds of a video and it links back to the real thing. Maybe it's promotional, could it be fair use? There's open arguments there. Is it covered by the license agreement? Well, the license agreement probably predates Facebook by a year or so. And who knows these things? But as a new media lawyer for a traditional media company, I think you have to ask the question, what does the Web 2.0 startup do? Do they ask? Probably not. What does Google do? Do they ask? Well, who knows? You got to sort of be aggressive on the licensing.
Actually, Jim was first.
I just want to make a point in response to Teresa. There is no such thing as the internet. It doesn't exist as a thing, as a juridical thing. What's key in these agreements is talking about the language that is spoken between networks and devices that we call the internet, which is TCP/IP. Kevin's point is right on. An iPhone, if it speaks TCP/IP, and it does, acts like a Mac. And you, if you're selling the content and putting out, are not going to know that it's an iPhone. you're going to think it's a match. So that's what Kevin was talking about. You could be in violation from day one. So you have to be very careful about these types of provisions when you license content. And the content writer, just as Kevin says, wants to put you in a tiny box. And if you're not careful, the agreement can be in breach from day one because you can't distinguish between some kinds of devices.
Yeah, Kevin, you talked about the closed box scenario of cable companies, for example, delivering content over a wire. You talked about broadband. What about the in-between? And this goes back to what Jerry said earlier in terms of profiting from copyright content. What about the in-between, which may be classified as fair use? So, for example, take the Sling box, right? You've got a device that some may classify as being fair use because it's not storing content, but it's allowing users to view their own content. What if they're profiting off of content that is being slinged, I guess, off of a set-top box? What if they're wrapping ads around the content? Is that in violation of the Digital Millennium Act?
I think we could all take a swing at this question. I mean, the short answer, well, who knows, is that we don't have a Supreme Court case on this, obviously. So this is a gray area. I can share my what's the best word for this? I mean, moderate annoyance and distinctions in the law between the device maker and the service provider along things like this. Where a device, I mean, you have the Sony case, someone who made Betamax or any sort of DVR, distribute that DVR. It's used occasionally for something that might be considered infringing, but there's no doubt under the law that Sony can do that. Doesn't seem to be a huge doubt under the law that Apple can distribute as many iPods as possibly can, though we know that there's a lot of file sharing or trading of music files that could be unlawful. So who knows? I mean, it is interesting that a service provider can be in a different situation under that than a company that actually makes a license.
I'm about to fail as a moderator. If I don't there's one thing I wanted to talk about before we just threw it open generally to questions, and that is I wanted Cliff to be able to spend a few minutes talking about online advertising and focusing very much on content. Everybody's got to monetize their sites these days. I want to let Cliff spend a few minutes just teeing those issues up, and we'll spend the rest of the time on questions that all you have. Thank you for your patience. Cliff.
Okay. Well, let me just briefly highlight a few issues in online advertising that I think are illustrative of the kinds of issues that are out there. And as David was saying, given the importance of online advertising for the future of media companies. And so let me just give you a few examples of different categories that I think are important. And one of them is intellectual property issues and advertising. And what I mean by that is that as online advertising continues to accelerate and grow, there are a lot of entities that are trying to make money off of it. And an example of litigation that Jerry and Barbara and I were all involved in a couple of years ago against a company then called Gator, which had software on millions of users' computers. It was downloaded with Kazaa and other programs. And it came to our attention that they were going to blue chip advertisers and our advertisers and saying, we can get ads for you, pop-up ads on WashingtonPost.com, New York Times site, advanced publication sites. And so this was a direct competitive threat to, and they were getting kind of great advertisers on that. And so 6 media companies, ours and the New York Times and Dow Jones and Tribune, if I remember right, sued Gator claiming trademark and copyright infringements. And we got an injunction against them, and the case eventually settled. But I think it's a good illustration of the kind of the intertwining of intellectual property issues and online advertising issues, and I think we're going to see a lot more of those. I think one issue that may come up in the next couple of years, and I'll just flag it, is ad blocking software, which is out there, which strips ads from websites, which would, be kind of a direct central threat to a very important business proposition and business potential for the future. Right now, the adoption of this ad blocking software is fairly low, but if it ever kind of gets traction, and you can think of scenarios where it would, I think that's going to pose some very interesting and important issues. Second area, just to flag, and then we can get to some of the questions, is the regulatory and legislative area. And there have been things like the CAN spam legislation with the requirements about spam. And the FTC, Federal Trade Commission, is getting, has been active in the past, and it recently has been looking at, as many of you may know, behavioral advertising and the use of cookies. And and they have some proposed principles that are out there, and there's a comment period until April. One of the most notable factors in their proposed principles would be requiring affirmative express consent for basically for the use of information, which would be a radical change, even non-personal information. And one of the things that I think is very important for quality online publications and publishers to get very involved in this kind of regulatory and legislative discussion, because a lot of times what can happen is that agencies or Congress or states can be acting against what they see as kind of bad actors on the internet and have no idea of how it's going to hit quality sites. And this happened with CAN spam, and I won't go into the gory details, but it had a kind of unusual, counterproductive consequence, I think, for quality sites. And I mean, I've talked to staffers who were involved in the legislation who had no idea it was going to have that effect on sites like us. And that's our fault for not kind of, being on top of it and laying out the possible consequences. And the last thing that I just want to flag is an area that I think at some point is going to really explode. But I will confess I've been predicting this for a while and it hasn't yet, is political advertising online. And there are some legal issues that come up with that. But right now there's this very strange gap between what the corporate world is doing and what the political world is doing with online advertising. With the corporate world, it is now a settled proposition for all mainstream companies and agencies that an important part of their budget has to go to online advertising as part of the fractured media landscape, and their debate should be 10%, should be 15%. And the threshold question, I think, is over. That's not true at all in the political world. You see very little actual political online advertising. People talk about the internet campaign. It's all about kind of email lists and websites. And there's very little use of it as a message vehicle. I saw one estimate that this year there's going to be $4 billion in political advertising, and $20 million is estimated to go to online. So it's a half of a percent, and half of that is going to paid search advertising. So for kind of display advertising, 10 million out of 4 billion. If this was a kind of corporate campaign, that would be dramatically more money. Now, I think that's going to have tremendous business implications when that happens, just as with television stations in even number of years, political advertising is very important. On the legal side, just very briefly, the FCC requirements on political advertising do not apply at this point online. On the other hand, the FEC, the Federal Election Commission, are ones that you can't unduly favor one side or the other, or giving corporate assets. Those completely apply. And I also think, as political advertising develops, that beyond the kind of confines of the regulations, that it is very important to have principles and procedures in place to show that you are being fair to all candidates and all parties, that you're giving them an equal opportunity for the advertising.
Now, I'll just interject something. Actually, one of our TV websites had a number of banner ads through a political campaign on the website. And immediately, users started to complain because they perceived, because it was on the homepage, that the station had decided to endorse a political candidate whose banner ad appeared at the time.
I think that's a very interesting point that we're noticing too. For some reason, an ad can run on Comcast cable political ad.
And nobody pays attention.
No one thinks that
That's the
Comcast is
connection.
responsible for the ad. They think we took money and advertised with us.
Yes.
Same ad runs on Comcast.net, our homepage for most of our high-speed internet subscribers. People do get the mistaken impression that we're sponsoring this candidate.
And they don't think that for other types of ads, they want to use the same spot.
It's an interesting disassociation between a banner ad on a web page
And this was a particularly unfortunate situation where the banner ad was at the top of the page. So it did.
because that's what they want to pay for.
Because that's what they wanted to pay for.
And I think that's in part of transition issue because
think
people haven't seen it online.
Yeah.
But I do think that the usual rules about labeling and disclosure and being clear what's advertising and what's not are especially important
With political advertising, exactly.
So would you put on a banner ad paid for by the Obama presidential campaign?
Well, the thing is, I believe it was there, but it just, it's in small type and you see the big Obama ad. Actually, it's Clinton, but you saw the big Clinton ad and the fine print didn't
We could
act
probably
as
have
full.
an hour session on what the political ad guidelines look like. It's a little bit off topic, but it is,
Yeah.
the disclosure requirements, make sure no one's buying up, a whole site or going to buy it too big, or blocking those kind of things. And plus a committee to review it, because it's real work, but I think people will decide on it.
One quick comment, and then we should, we're running out of time to take a couple of questions. Going back to the Gator case that Cliff described, this is going to be a continuing battle. After Gator, there were a bunch of other cases on whether individuals, users, can download what they would think of as their own device, their own software that might, there were 3 cases called when you cases. When you would sell a device, sell a program that essentially would pop up what when you calls a comparator ad. When you visit one website, an ad would pop up for a competitor of that website. Those cases went the opposite direction from Gator.
But those are commercial websites, not news websites.
Right. That would be, you're on Eddie Bauer and then up pops a Land's End catalog ad. And those were all held to be okay, partly because when you as the spyware like Gator, it gets on because people know what's going on in their computer, and 2, it's viewed as an empowerment of the user, a little bit different. But that's going to be a continuing tension between your website and your users. I mean, who owns that real estate that's they're looking at on your screen is going to be a continuing question. Why don't we take just a minute or 2 with a bunch of hands? You've been very patient.
Not really. But just going back to the question around behavioral targeting, and I've been watching that process be underway for a little while now. It seems like most of the focus is on privacy rights versus copyrights. And I just wonder whether you see that being reframed, given the fact that users are actually supplying content themselves in increasing instances, and the degree, the forms of monetization that are taking place are going to increasingly rely upon information that is maybe passively generated by users or interactively generated by users as they navigate within and across sites. I mean, are the types of laws and the types of precedents that are being applied to this actually applicable? If not, what would be a more productive way to address what are effectively an intermingling of interests amongst parties who include not only copyright holders, advertisers, but also users who become providers of content and navigators across respective areas of legal ownership?
Well, I mean, in terms of kind of the questions with behavioral advertising, I think that the system which has been in place, and which is, essentially kind of self-regulatory regimes and privacy policies and that kind of thing, and maybe this is just based on kind of my perspective at our websites, but I actually think it works. It works fine, and people there are. The privacy policies there, people say, oh, people don't read them. If they're concerned, they can read them. There's a chance that there's an opportunity to opt out. There are kind of, browser and cookie management tools in your browser, and maybe sites could do more to educate people about it. But I think, for the past several years, the, regime has been that self-regulation is better because it can be kind of dynamic in a rapidly changing medium, and that if you have a kind of FTC, whether you have rules or statutes that kind of, are rigid, that it's not going to be responsive. So, I mean, that is my take.
I think a good example of that, exactly what you're saying, is the flap over Facebook's use of Beacon, which, they started to use shortly before the Christmas shopping season, and it allowed information about purchases that were being made by Facebook users to appear on the screen. And there was, at Now, the FTC didn't have to get involved in that, and indeed, my perception is that the things that many of the users object to develop quite quickly, far too rapidly for the government agencies to respond, and businesses tend to be rational actors who don't want to have users who are reacting negatively to the things that they're doing to monetize their sites. So, I mean, I agree with Cliff that self-regulation, particularly with things moving so quickly, until somebody can demonstrate that the system is completely broken, I think should be allowed to continue to develop.
I just want to chime in a little bit, so I agree with everything Cliff and Barbara said, but the public debate seems to be going a little bit differently, so I'm more wary of what the FTC might do on this. And there was a stat, I wish I could remember whose stat it was, but it was in the New York Times the other day. The stat was 85% of people polled, I believe this was, thought that any sort of anonymous tracking of their behavior online, selling ads, should be prohibited.
Even exit.
Right, and that is not the world. I mean, and I'm not talking about the gators and other alleged bad actors. I mean, these are the Yahoos and everybody else that are selling ads that are made more relevant. I won't even say targeted, made more relevant because of information they know about cookies tied to other sites on which they sell advertising on all sorts of user's computer. So you don't know what. If the FTC listens to business and are pleading for self-regulation, they could get it right, but there is a chance that it could be perceived the other way by privacy advocates. It's an interesting world.
The conference organizer just stuck his head in the door and gave me the sign that we should be cutting it off. If you have questions, I'm very conscious of you being everybody. Come up and find us. We'd love to chat with you. But please join me in thanking this all-star panel for